Election laws. Representation of the People ACT, 1950. Articles 81 and 170 of the Constitution of India lay down the maximum number of seats in Parliament and in legislative assemblies of states and also certain principles to be followed in allocating seats in the House of People among the states and in the state legislative assemblies, but have left the actual allocation of such seats to be provided by the law. Similarly, Article 171 of the Constitution of India lays down the maximum and minimum number of seats in the Legislative Council of a state, and also specify the various methods in which the seats shall be filled, but the actual number of seats to be filled by each such method has been left to be provided by law. Therefore, the Representation of the People Act, 1950, was enacted to provide for the allocation of seats in the House of the People and in the legislative assemblies and legislative councils of states. The Act also sought to confer on the President the powers to delimit, after consultation with the Election Commission, the various constituencies for the purpose of elections to fill seats in the House of the People and in the legislative assemblies and legislative councils of states. The Act further provided for the registration of electors for parliamentary constituencies and for the assembly and council constituencies, and the qualifications and disqualifications for such registration. To sum up, the Act makes the following provisions relating to the elections. 1. Allocation of seats in the House of the People, the state legislative assemblies and the state legislative councils. 2. Delimitation of parliamentary, assembly and council constituencies. 3. Election officers like chief electoral officers, district election officers, electoral registration officers and so on. 4. Electoral rolls for parliamentary, assembly and council constituencies. 5. Manner of filling seats in the Council of States to be filled by representatives of Union territories. 6. Local authorities for purposes of elections to the state legislative councils. 7. Barring the jurisdiction of civil courts. Representation of the People ACT, 1951. The Representation of the People Act, 1950 did not contain all the provisions relating to elections but merely provided for the allocation of seats in and the delimitation of constituencies for the purpose of elections to the House of People and legislatures of states, the qualifications of voter at such election and the preparations of electoral rolls. The provisions for the actual conduct of elections to the Houses of Parliament and to the House or Houses of the legislature of each state, the qualifications and disqualifications for the membership of these houses, the corrupt practices and other election offences, and the decision of election disputes were all left to be made in a subsequent measure. In order to provide for these provisions, the Representation of the People Act, 1951 was enacted. Broadly speaking, this Act contains provisions relating to the following electoral matters. 1. Qualifications and disqualifications for membership of Parliament and state legislatures. 2. Notification of general elections. 3. Administrative machinery for the conduct of elections. 4. Registration of political parties. 5. Conduct of elections. 6. Free supply of certain material to candidates of recognized political parties. 7. Disputes regarding elections. 8. Corrupt practices and electoral offences. 9. Powers of Election Commission in connection with inquiries as to disqualifications of members. 10. By-elections and time limit for filling vacancies. 11. Miscellaneous provisions relating to elections. 12. Barring the jurisdiction of civil courts. The conduct of elections include the following matters. A. Nomination of candidates. B. Candidates and their agents. C. General procedure at elections. D. The poll. A. Counting of votes. F. Multiple elections. G. Publication of election results and nominations. H. Declaration of assets and liabilities. I. Election expenses. The provisions of the Act with respect to disputes regarding elections are related to the following matters. I. Presentation of election petitions to High Court. E. Trial of election petitions. E. Withdrawal and abatement of election petitions. IV. Appeals to Supreme Court. V. Costs and security for costs delimitation. ACT, 2002. Articles 82 and 170 of the Constitution of India provide for readjustment and the division of each state into territorial constituencies, parliamentary constituencies and assembly constituencies, on the basis of the 2001 census by such authority and in such manner as Parliament may, by law, determine. Further, Articles 330 and 332 of the Constitution of India provide for refixing the number of seats reserved for the scheduled castes and the scheduled tribes in the House of the People and legislative assemblies of the states on the basis of the 2001 census. The present delimitation of parliamentary and assembly constituencies is based on the 1971 census. The uneven growth of population in different constituencies in different parts of the country as well as within the same state is also continuous migration of people, electorate from one place to other especially from rural areas to urban areas have resulted in strikingly differing sizes of electoral constituencies even within the same state. Therefore, the Delimitation Act, 2021, was enacted to set up a delimitation commission for the purpose of effecting delimitation on the basis of the 2001 census so as to correct the aforesaid distortion in the sizes of electoral constituencies. The proposed delimitation commission would also refix the number of seats for the scheduled castes and the scheduled tribes on the basis of the 2001 census, without affecting total number of seats based on the 1971 census. The Act sought to lay down certain guidelines as to the manner in which such delimitation would be undertaken. In the Act, the new Delimitation Commission was given the task of carrying out delimitation of parliamentary and assembly constituencies. It had been specifically provided that the Delimitation Commission shall endeavor to complete the work within a period not later than July 31, 2008.2. The proposed delimitation would apply to every general election to the House of the People or to a state legislative assembly held after the final orders of the Commission are published and to every by-election arising from such general election. 3. Other acts relating to elections. 1. Parliament Prevention of Disqualification Act, 19,594 declares that certain offices of profit under the government shall not disqualify the holders thereof for being chosen as, or for being, members of Parliament. 2. Scheduled Castes and Scheduled Tribes Orders, Amendment, Act, 1976 provides for the inclusion in, and the exclusion from, the lists of scheduled castes and scheduled tribes, of certain castes and tribes, for the readjustment of representation of parliamentary and assembly constituencies. 3. Government of Union Territories Act, 1963. 4. Government of National Capital Territory of Delhi Act, 1991. 5. Presidential and Vice Presidential Elections Act, 1952. 5. Regulates certain matters relating to or connected with elections to the offices of the President and Vice President of India. Rules relating to elections. 1. Registration of Electors Rules, 19,606 provide for the preparation and publication of electoral rolls. 2. Conduct of Elections Rules, 19,617 facilitates conduct of fair and free elections to the Parliament and state legislatures. 3. Prohibition of Simultaneous Membership Rules, 1950. 4. Members of Lok Sabha, Disqualification on Ground of Defection, Rules, 1985. 5. Members of Rajya Sabha, Disqualification on Ground of Defection, Rules, 1985. 6. Presidential and Vice Presidential Elections Rules, 1974.87. Members of Lok Sabha, Declaration of Assets and Liabilities, Rules, 2004. 8. Members of Rajya Sabha, Declaration of Assets and Liabilities, Rules, 2004. Orders relating to elections. 1. Election Symbols, Reservation and Allotment, Order, 1968 provides for the specification, reservation, choice and allotment of symbols at elections in parliamentary and assembly constituencies, for the recognition of political parties in relation thereto. 2. Registration of political parties, furnishing of additional particulars, Order, 1992 provides for furnishing of additional particulars by associations or bodies of individual citizens of India seeking registration as a political party with the Election Commission of India. Notes and references. 1. The Delimitation Act, 2002, was amended in 2003, 2008 and 2016. 2. Originally, the Act provided for a period of 2 years. 3. Earlier, the Delimitation Acts were enacted in 1952, 1962 and 1972. 4. This Act repealed the 3 earlier acts, namely, the Parliament Prevention of Disqualification Act, 1950. The Parliament Prevention of Disqualification Act, 1951. And the Prevention of Disqualification, Parliament and Part C States Legislatures, Act, 1953. 5. This Act was amended in 1974, 1977 and 1997. 6. Earlier, the rules in this regard were made in 1950 and 1956. Both the earlier rules were known by the same nomenclature, i.e., the Representation of the People, Preparation of Electoral Rolls, Rules. 7. Earlier, the rules in this regard were made in 1951 and 1956. Both the earlier rules were known by the same nomenclature, i.e., the representation of the people, conduct of elections and election petitions, rules. 8. These rules repealed the earlier presidential and vice-presidential elections rules, 1952. 73 Electoral reforms. Committees related to electoral reforms. The various committees and commissions which have examined our electoral system, election machinery as well as election process and suggested reforms are mentioned here. 1. Joint Parliamentary Committee on Amendments to Election Laws, 1971-72. 2. Tarkunde Committee was appointed in 1974 by Jaya Prakash Narayan, JP, during his Total Revolution movement. This unofficial committee submitted its report in 1975. 3. Dinesh Goswami Committee on Electoral Reforms 1990-14. Vora Committee on the Nexus Between Crime and Politics 1993-5. Election Commission of India Recommendations on Electoral Reforms, 1998. 6. Indrajit Gupta Committee on State Funding of Elections 1998-7. Law Commission of India 170th Report on Reform of the Electoral Laws 1999-8. National Commission to Review the Working of the Constitution, 2002-002-3. It was headed by M.N. Venkatachalaya. 9. Election Commission of India Report on Proposed Electoral Reforms, 2004. 10. Second Administrative Reforms Commission of India Report on Ethics in Governance, 2007. It was headed by Veerappa Moily. 11. Tinkha Committee, Core Committee, was appointed in 2010 to look into the whole gamut of the election laws and electoral reforms. 12. J.S. Verma Committee Report on Amendments to Criminal Law, 2013. 13. Law Commission of India 244th Report on Electoral Disqualifications, 2014. 14. Law Commission of India 255th Report on Electoral Reforms, 2015. Based on the recommendations made by the above committees and commissions, various reforms have been introduced in our electoral system, election machinery, and election process. These can be studied under the following 4 heads. Electoral reforms before 1996, electoral reforms of 1996, electoral reforms after 1996, electoral reforms since 2010, electoral reforms before 1996. Lowering of voting age. The 61st Constitutional Amendment Act of 19,884 reduced the voting age from 21 years to 18 years for the Lok Sabha as well as the Assembly elections. This was done in order to provide to the unrepresented youth of the country an opportunity to express their feelings and help them become a part of political process. Deputation to Election Commission in 19885, a provision was made that the officers and the staff engaged in preparation, revision and correction of electoral rolls for elections are deemed to be on deputation to the Election Commission for the period of such employment. These personnel, during that period, would be under the control, superintendence and discipline of the Election Commission. Increase in number of proposers in 19886. The number of electors who are required to sign as proposers in nomination papers for elections to the Rajya Sabha and State Legislative Council has been increased to 10% of the electors of the constituency or 10 such electors, whichever is less. This was done in order to prevent non-serious candidates from contesting frivolously. Electronic voting machines in 19897. A provision was made to facilitate the use of electronic voting machines, EVMs, in elections. The EVMs were used for the first time in 1998 on experimental basis in selected constituencies in the elections to the assemblies of Rajasthan, Madhya Pradesh and Delhi. The EVMs were used for the first time in the general elections, entire state, to the Assembly of Goa in 1999. Booth capturing in 19898. A provision was made for adjournment of poll or countermanding of elections in case of booth capturing. Booth capturing includes I. Seizure of a polling station and making polling authorities surrender ballot papers or voting machines. E. Taking possession of polling station and allowing only one's own supporters to exercise their franchise. E. Threatening and preventing any elector from going to polling station. And IV. Seizure of the place being used for counting of votes. Electors' Photo Identity Card, EPIC. The use of electors' photo identity cards by the Election Commission is surely making the electoral process simple, smoother and quicker. A decision was taken by the Election Commission in 1993 to issue photo identity cards to electors throughout the country to check bogus voting and impersonation of electors at elections. The electoral roll is the basis for issue of epochs to the registered electors. The electoral rolls are normally revised every year with the 1st of January of the year as the qualifying date. Every Indian citizen who attained the age of 18 years or above as on that date is eligible for inclusion in the electoral roll and can apply for the same. Once he is registered in the roll, he would be eligible for getting an epoch. The scheme of issuing the epochs is, therefore, a continuous and ongoing process for the completion of which no time limit can be fixed, as the registration of electors is a continuous and ongoing process, excepting for a brief period between the last date for filing nomination and completion of electoral process, on account of more number of persons becoming eligible for the right of franchise on attaining the age of 18. It is the continuous effort of the Election Commission to provide the epochs to the electors who have been left out in the previous campaigns as well as the new electors. 8A Electoral Reforms of 1996. In 1990, the National Front government headed by V.P. Singh appointed a committee on electoral reforms under the chairmanship of Dinesh Goswami, the then law minister. The committee was asked to study the electoral system in detail and suggest measures for remedying the drawbacks within it. The committee, in its report submitted in 1990 itself, made a number of proposals on electoral reforms. Some of these recommendations were implemented in 19969. These are explained here. Listing of names of candidates. The candidates contesting elections are to be classified into three categories for the purpose of listing of their names. They are I. Candidates of recognized political parties, E. Candidates of registered unrecognized political parties, E. Other independent candidates. Their names in the list of contesting candidates and in the ballot papers has to appear separately in the above order, and in each category these have to be arranged in the alphabetical order. Disqualification for insulting the National Honor Act. A person who is convicted for the following offences under the Prevention of Insults to National Honor Act of 1971 is disqualified to contest in the elections to the Parliament and State Legislature for 6 years. I. Offence of insulting the national flag. E. Offence of insulting the Constitution of India. E. Offence of preventing the singing of national anthem. Prohibition on the sale of liquor. No liquor or other intoxicants are to be sold or given or distributed at any shop, eating place, hotel or any other place, whether public or private, within a polling area during the period of 48 hours ending with the hour fixed for the conclusion of poll. Any person who violates this rule is to be punished with imprisonment up to 6 months or with fine up to 2,000 rupees or with both. Number of proposers. The nomination of a candidate in a parliamentary or assembly constituency should be subscribed by 10 registered electors of the constituency as proposers, if the candidate is not sponsored by a recognized political party. In the case of a candidate sponsored by a recognized political party, only one proposer is required. This was done in order to discourage non-serious people from contesting the elections. Death of a candidate earlier. In case of death of a contesting candidate before the actual polling, the election used to be countermanded. Consequently, the election process had to start all over again in the concerned constituency. But now, the election would not be countermanded on the death of a contesting candidate before the actual polling. However, if the deceased candidate belonged to a recognized political party, the party concerned would be given an option to propose another candidate within 7 days. Time limit for by-elections. Now, by-elections are to be held within 6 months of occurrence of the vacancy in any House of Parliament or a state legislature. But, this condition is not applicable in two cases. I. Where the remainder of the term of the member whose vacancy is to be filled is less than 1 year. Or E. When the Election Commission, in consultation with the central government, certifies that it is difficult to hold the by-elections within the said period. Holiday to employees. On the polling day, the registered voters employed in any trade, business, industry or any other establishment are entitled to a paid holiday on the polling day. This rule applies even to the daily wages. Any employer who violates this rule is to be punished with a fine up to 500 rupees. However, this rule is not applicable in the case of a voter whose absence may cause danger or substantial loss in respect of the employment in which he is engaged. Contestants restricted to 2 constituencies. A candidate would not be eligible to contest from more than 2 parliamentary or assembly constituencies at a general election or at the by-elections which are held simultaneously. Similar restrictions are imposed for biennial elections and by-elections to the Rajya Sabha and the state legislative councils. Prohibition of arms. Entering into the neighborhood of a polling station with any kind of arms 10 is to be considered a cognizable offense. Such an act is punishable with imprisonment of up to 2 years or with fine or with both. Further, the arms found in possession of the offender are to be confiscated and the related license is to be cancelled. But, these provisions are not applicable to the returning officer, presiding officer, any police officer, or any other person appointed to maintain peace and order at the polling station. Effective campaigning period reduced. The minimum gap between the last date for withdrawal of candidature and the polling date has been reduced from 20 to 14 days. Electoral reforms after 1996. Presidential and vice presidential elections in 199,711. The number of electors as proposers and seconders for contesting election to the office of the president was increased from 10 to 50 and to the office of the vice president from 5 to 20. Further, the amount of security deposit was increased from 2,500 rupees to 15,000 rupees for contesting election to both the offices of president and vice president to discourage frivolous candidates. Requisitioning of staff for election duty in 199,812. A provision was made whereby the employees of local authorities, nationalized banks, universities, LIC, government undertakings and other government-aided institutions can be requisitioned for deployment on election duty. Voting through postal ballot in 199,913. A provision was made for voting by certain classes of persons through postal ballot. Thus, any class of persons can be notified by the Election Commission, in consultation with the government, and the persons belonging to such notified class can give their votes by postal ballot, and not in any other manner, at elections in their constituency or constituencies. Facility to opt to vote through proxy in 200,314. The facility to opt to vote through proxy was provided to the service voters belonging to the armed forces and members belonging to a force to which provisions of the Army Act apply. Such service voters who opt to vote through proxy have to appoint a proxy in a prescribed format and intimate the returning officer of the constituency. Declaration of criminal antecedents, assets, etc. By candidates in 2003, the Election Commission issued an Order 15 directing every candidate seeking election to the Parliament or a state legislature to furnish on his nomination paper the information on the following matters. I. Whether the candidate has been convicted or acquitted or discharged in any criminal offense in the past. Whether she was imprisoned or fined. E. Prior to 6 months of filing nomination, whether the candidate is accused in any pending case, of any offense punishable with imprisonment for 2 years or more, and in which charges were framed or cognizance was taken by a court. If so, the details thereof, e. the assets, movable, bank balances, etc. of a candidate and her spouse and that of dependents, iv. liabilities, if any, particularly whether there are any dues of any public financial institution or government dues, b. the educational qualifications of the candidate. Furnishing of any false information in the affidavit is now an electoral offence punishable with imprisonment up to 6 months or fine or both. Changes in Rajya Sabha elections. In 2003, the following 2 changes were introduced with respect to elections to the Rajya Sabha 16. I. Domicile or residency requirement of a candidate contesting an election to the Rajya Sabha was removed. Prior to this, a candidate had to be an elector in the state from where he was to be elected. Now, it would be sufficient if he is an elector in any parliamentary constituency in the country. E. Introducing open ballot system, instead of secret ballot system, for elections to the Rajya Sabha. This was done to curb cross-voting and to wipe out the role of money power during Rajya Sabha elections. Under the new system, an elector belonging to a political party has to show the ballot paper after marking his vote to a nominated agent of that political party. Exemption of travelling expenditure as per a provision of 200,317. The travelling expenditure incurred by the campaigning leaders of a political party shall be exempted from being included in the election expenses of the candidate. Free supply of electoral rolls, etc. According to a 2003 provision 18, the government should supply, free of cost, the copies of the electoral rolls and other prescribed material to the candidates of recognized political parties for the Lok Sabha and Assembly elections. Further, the Election Commission should supply specified items to the voters in the constituencies concerned or to the candidates set up by the recognized political parties. Parties entitled to accept contribution in 200,319. The political parties were entitled to accept any amount of contribution from any person or company other than a government company. They have to report any contribution in excess of 20,000 rupees to the Election Commission for making any claim to any income tax relief. Besides, the companies would get income tax exemption on the amount contributed. Allocation of time on electronic media under a 2003 Provision 20. The Election Commission should allocate equitable sharing of time on the cable television network and other electronic media during elections to display or propagate any matter or to address public. This allocation would be decided on the basis of the past performance of a recognized political party. Introduction of Braille signage features in EVMs. The Commission received representations from the various associations of visually impaired persons for introduction of Braille signage features in the EVMs to facilitate the visually impaired voters to cast their votes without the help of attendant. The Commission considered the proposal in detail and tried the Braille signage feature in the EVMs during the by-election to the Asifnagar Assembly constituency of Andhra Pradesh held in 2004. In 2005, it was tried in one of the constituency during the assembly elections of Bihar, Jharkhand and Haryana. In 2006, it was tried in one of the constituency of the states of Assam, West Bengal, Tamil Nadu, Puducherry and Kerala during assembly elections. In 2008, it was tried in all the assembly constituencies of NCT of Delhi during assembly elections. The Commission introduced similar Braille signage features on the electronic voting machines during the general elections to the 15th Lok Sabha, 2009, and simultaneous assembly elections in some states. 20A electoral reforms since 2010. Restrictions imposed on exit polls. According to a 2009 Provision 21, conducting exit polls and publishing results of exit polls would be prohibited during the election to Lok Sabha and state legislative assemblies. Thus, no person shall conduct any exit poll and publish or publicize by means of the print or electronic media or disseminate in any other manner the result of any exit poll during the period notified by the Election Commission in this regard. Further, any person who contravenes this provision shall be punishable with imprisonment of up to 2 years or with fine or with both. Exit poll is an opinion survey regarding how electors have voted at an election or how all the electors have performed with regard to the identification of a political party or candidate in an election. Time limit for submitting a case for disqualification in 200,922. A provision was made for the simplification of the procedure for disqualification of a person found guilty of corrupt practices. It provided for a 3-month time limit within which the specified authority will have to submit the case of a person found guilty of corrupt practice to the President for determination of the question of disqualification. All officials included in corrupt practice in 200,923, a provision was made for the inclusion of all officials, whether in the government service or not, appointed or deputed by the Election Commission in connection with the conduct of elections, within the scope of corrupt practice of obtaining any assistance by a candidate for the furtherance of the prospects of his election. Increase in security deposit in 200,924. The amount of security deposit to be paid by the candidates contesting elections to the Lok Sabha was increased from 10,000 rupees to 25,000 rupees for the general candidates and from 5,000 rupees to 12,500 rupees for SC and ST candidates. Similarly, the security deposit in the case of elections to the State Legislative Assembly was increased from 5,000 rupees to 10,000 rupees for the general candidates and from 2,500 rupees to 5,000 rupees for the SC and ST candidates. This was done in order to check the multiplicity of non-serious candidates. Appellate authority within the district in 200,925, a provision was made for appointment of an appellate authority within the district against the orders of the electoral registration officers, instead of the chief electoral officer of the state. Thus, an appeal against any order of the electoral registration officer of a constituency, during continuous updation of the electoral roll, will now lie before the district magistrate or additional district magistrate or executive magistrate or district collector or an officer of equivalent rank. A further appeal against any order of the district magistrate or additional district magistrate will now lie before the chief electoral officer of the state. Voting rights to citizens of India living abroad in 201,026, a provision was made to confer voting rights to the citizens of India residing outside India due to various reasons. Accordingly, every citizen of India, a, whose name is not included in the electoral roll, b, who has not acquired the citizenship of any other country, c, who is absent from his place of ordinary residence in India owing to his employment, education or otherwise outside India, whether temporarily or not, shall be entitled to have his name registered in the electoral roll in the parliamentary assembly constituency in which his place of residence in India is mentioned in his passport is located. Online enrollment in the electoral roll. In 2013, a provision was made for online filing of applications for enrollment in the electoral roll. For this purpose, the central government, after consulting the Election Commission, made the rules known as the Registration of the Electors Amendment Rules 2013.27. These rules made certain amendments in the Registration of Electors Rules 1960. Introduction of notar option. According to the directions of Supreme Court, the Election Commission made provision in the ballot papers, EVMs, for none of the above, notar option, so that the voters who come to the polling booth and decide not to vote for any of the candidates in the fray, are able to exercise their right not to vote for such candidates while maintaining the secrecy of their ballot. The provision for notar has been made since general election to state legislative assemblies of Chhattisgarh, Madhya Pradesh, Mizoram, NCT of Delhi and Rajasthan in 2013, and continued in the general election to state legislative assemblies of Andhra Pradesh, Arunachal Pradesh, Orissa and Sikkim in 2014, along with the general elections to the 16th Lok Sabha, 2014. 28. The voters polled against the notar option are not taken into account for calculating the total valid voters polled by the contesting candidates for the purpose of return of security deposits to candidates. Even if the number of electors opting for notar options is more than the number of votes polled by any of the candidates, the candidate who secures the largest number of votes has to be declared elected. 29. In 2001, the ACI had sent a proposal to the government to amend the law so as to provide for a neutral vote provision for the electors who did not wish to vote for any of the candidates. In 2004, PUCL, People's Union for Civil Liberties, filed a petition seeking a direction to provide the necessary provision in ballot papers and EVMs for protection of the right to not vote for any candidate, secretly. The Supreme Court in 2013 held that the ACI may provide for the none of the above, notar option on EVMs and ballot papers. 30. Introduction of VVPAT. The Voter Verifiable Paper Audit Trail is an independent system attached with the EVMs that allows the voters to verify that their votes are cast as intended. When a vote is cast, a slip is printed and remains exposed through a transparent window for 7 seconds, showing the serial number, name and symbol of the candidate. Thereafter, the receipt automatically gets cut and falls into the sealed drop box of the VVPAT. The system allows a voter to challenge his/her vote on the basis of the paper receipt. As per rules, the presiding officer of the polling booth will have to record the dissent of the voter, which would have to be taken into account at the time of counting, if the challenge is found to be false. 31. The law for using VVPATs was amended in 2013. In 2013, the Supreme Court of India had permitted the ACI to introduce VVPAT in a phased manner, calling it an indispensable requirement of free and fair elections. The court had felt that introducing VVPAT would ensure the accuracy of the voting system and also help in manual counting of votes in case of dispute. VVPATs were first used in by-election to the Naxeen Assembly constituency of Nagaland held in 2013. Thereafter, VVPATs have been used in selected constituencies during every general election to state legislative assemblies. VVPATs were used in 8 selected parliamentary constituencies in the country in the 2014 Lok Sabha election. EVMs with VVPAT ensure the accuracy and transparency of the voting system. 32. Persons in jail or police custody can contest elections in 2013. 33. The Supreme Court upheld an order of the Patna High Court declaring that a person who has no right to vote by reason of being in jail or in police custody is not an elector and is, therefore, not qualified to contest the elections to the parliament or the state legislature. In order to negate this order of the Supreme Court, the following 2 new provisions 34 have been included in the Representation of the People Act, 1951. The first provision expressly provides that by reason of the prohibition to vote, either due to in jail or in police custody, a person whose name has been entered in the electoral roll shall not cease to be an elector. The second provision expressly provides that a member of parliament or the state legislature shall be disqualified only if he is so disqualified under the provisions contained in the Act and on no other ground. Consequently, the persons in jail or in police custody are allowed to contest the elections. Immediate disqualification of convicted MPs and MLAs in 2013. 35. The Supreme Court held that charge-sheeted members of parliament and MLAs, on conviction for offences, will be immediately disqualified from holding membership of the House without being given 3 months' time for appeal, as was the case before. The concerned bench of the court struck down as unconstitutional Section 8(4) of the Representation of the People Act, 1951, that allows convicted lawmakers a 3-month period for filing appeal to the higher court and to get a stay of the conviction and sentence. The bench, however, made it clear that the ruling will be prospective and those who had already filed appeals in various high courts or the Supreme Court against their convictions would be exempt from it. The bench said, a reading of the two provisions in Articles 102 and 191 of the Constitution would make it abundantly clear that Parliament is to make one law for a person to be disqualified for being chosen as, and for being, a member of either House of Parliament or Legislative Assembly or Legislative Council of the state. Parliament thus does not have the power under Articles 102 and 191 of the Constitution to make different laws for a person to be disqualified for being chosen as a member and for a person to be disqualified for continuing as a member of Parliament or the state legislature. The bench said, Section 8(4) of the Act, which carves out a saving in the case of sitting members of Parliament or state legislature from the disqualifications under the Act, or which defers the date on which the disqualification will take effect in the case of a sitting member of Parliament or a state legislature, is beyond the powers conferred on Parliament by the Constitution. The bench held, looking at the affirmative terms of Articles 102 and 191 of the Constitution, we hold that Parliament has been vested with the powers to make law laying down the same disqualifications for person to be chosen as a member of Parliament or a state legislature and for a sitting member of a House of Parliament or a House of a state legislature. We also hold that the provisions of Article 101 and 190 of the Constitution expressly prohibit Parliament to defer the date from which the disqualification will come into effect in case of a sitting member of Parliament or a state legislature. Parliament, therefore, has exceeded its powers conferred by the Constitution in enacting subsection 4 of Section 8 of the Act, and accordingly subsection 4 of Section 8 of the Act is ultra vires the Constitution 36. In order to nullify the above ruling of the Supreme Court, the Representation of the People, Second Amendment and Validation Bill, 2013 was introduced in the Parliament. However, the bill was later withdrawn by the government. Ceiling on election expenditure increased in 201,437. The central government raised the maximum ceiling on election expenditure by candidates for a Lok Sabha seat in bigger states to 70 lakh rupees, from earlier 40 lakh rupees. In other states and union territories, it is 54 lakh rupees, from earlier 16 rupees 40 lakhs. Similarly, the limit for an assembly seat in the bigger states was increased to 28 lakh rupees, from earlier 16 lakh rupees. In other states and union territories, it is 20 lakhs, from earlier 8 rupees 16 lakhs. The state-wise limits are mentioned in Table 73.1 at the end of this chapter. Photos of candidates on EVMs and ballot papers. According to an Election Commission order, in any election being held after May 1, 2015, the ballot papers and EVMs will carry the picture of the candidate with his or her name and party symbol to avoid confusion among the electorates in constituencies where namesakes are contesting. The June 2015 by-polls to 6 seats in 5 states were the first elections where photographs of candidates were used on ballot papers. The Commission has noted that there are many cases where candidates with same or similar names contest from the same constituency. Although appropriate suffixes are added to the names of candidates in the event of 2 or more candidates having same name, the Commission considers that additional measures are required for removing confusion in the minds of electors at the time of voting. The photograph will appear between the name of the candidate and his or her election symbol. The Commission explained that if a candidate fails to provide the photograph, it shall not be a ground for the rejection of the nomination of the candidate. The candidates will now be required to submit their recent photograph, either black and white or colored, to the election authorities at the time of filing nomination. No uniforms would be allowed and caps and dark glasses have to be avoided. 38. Ceiling on cash donations lowered. In 2017 budget, the limit for anonymous cash donations by any individual to a political party has been lowered from 20,000 rupees to 2,000 rupees. This means that now the political parties cannot receive more than 2,000 rupees as cash donations. However, they are not required to inform the Election Commission of India the details of persons who donate under 2,000 rupees. They must keep records of persons making above 2,000 rupees donations. Cap on corporate contributions lifted. In 2017 budget, the limit on corporate contributions from 7.5% of the net profit of a company's past 3 financial years has been removed. This means that now a company can donate any amount of money to any political party. Further, the obligation of the company to report such donations in its profit and loss account has also been lifted. Introduction of electoral bonds. In 2018, the central government notified the electoral bond scheme. This scheme was announced in the 2017 budget. It is touted as an alternative to cash donations made to the political parties. It is aimed at bringing clean money and substantial transparency into the system of political funding. The salient features of the scheme are: I. The electoral bond means a bond issued in the nature of promissory note, which is a bearer banking instrument and does not carry the name of the buyer or payee. E. The electoral bonds may be purchased by a citizen of India or entities incorporated or established in India. E. The electoral bonds can be used for making donations to only those registered political parties which have secured not less than 1% of the votes polled in the last general election to the Lok Sabha or the State Legislative Assembly. IV. The electoral bonds can be encashed by an eligible political party only through a bank account with the authorized bank. V. The electoral bonds are issued in the denomination of 1,000 rupees, 10,000 rupees, 100,000 rupees, 1 million rupees and 10 million rupees. V. The information furnished by the buyer is treated confidential by the authorized bank and is not to be disclosed to any authority for any purposes, except when demanded by a competent court or upon registration of criminal case by any law enforcement agency. Foreign funding allowed. In 2018 budget, the receiving of foreign funds by the political parties has been allowed. In other words, the political parties can now receive funds from the foreign companies. Accordingly, the Foreign Contribution Regulation Act 2010 has been amended. Under this amendment, the definition of a foreign company has been modified. Table 73.1 Limit on election expenditure, as declared in 2014. SL. No. Name of state or union territory. Maximum limit of election expenses in any one parliamentary constituency. Assembly constituency. I. States rupee 1 rupee Andhra Pradesh 7,000,000 2,800,000 2 Arunachal Pradesh 5,400,000 2 million. 3 Assam 7,000,000 2,800,000 4 Bihar 7,000,000 2,800,000 5 Goa 5,400,000 2 million 6 Gujarat 7,000,000 2,800,000 7 Haryana 7,000,000 2,800,000 8 Himachal Pradesh 7,000,000 2,800,000 9 Jammu and Kashmir 7 million. 10 Karnataka 7,000,000 2,800,000 11 Kerala 7,000,000 2,800,000 12 Madhya Pradesh 7,000,000 2,800,000 13 Maharashtra 7,000,000 2,800,000 14 Manipur 7,000,000 2,000,000 15 Meghalaya 7,000,000 2,000,000 16 Mizoram 7,000,000 2,000,000 17 Nagaland 7,000,000 2,000,000 18 Orissa 7,000,000 2,800,000 19 Punjab 7,000,000 2,800,000 20 Rajasthan 7,000,000 2,800,000 21 Sikkim 5,400,000 2,000,000 22 Tamil Nadu 7,000,000 2,800,000 23 Tripura 7,000,000 2,000,000 24 Uttar Pradesh 7,000,000 2,800,000 25 West Bengal 7,000,000 2,800,000 26 Chhattisgarh 7,000,000 2,800,000 27 Uttarakhand 7,000,000 2,800,000 28 Jharkhand 7,000,000 2,800,000 29 Telangana 7,000,000 2,800,000 2 Union Territories 1 Andaman and 5,400,000 Nicobar Islands 2 Chandigarh 54,000 3 Dadra and Nagar Haveli 5,400,000 4 Daman and Diu 54,000 5 Delhi 7,000,000 2,800,000 6 Lakshadweep 54,000 7 Puducherry 5,400,000 2 million. Notes and references. 1. C. Electoral reforms of 1996, discussed later in this chapter. 2. In 1998, the BJP-led government appointed an 8-member committee on state funding of elections under the chairmanship of Indrajit Gupta, a former Home Minister. The committee submitted its report in 1999. It upheld the argument for introduction of state funding of elections. It stated that state funding of elections is constitutionally and legally justified and is in public interest. 3. For recommendations of the Commission in this regard, see Chapter 80. 4. This came into force on March 28, 1989. Consequently, amendments were also made in the Representation of the People Act of 1950 and 1951. 5. Representation of the People, Amendment, Act of 1988. 6. IBAD. 7. Amendment to the Representation of the People Act of 1951 with effect from March 15, 1989. 8. Section 58A has been inserted in the Representation of the People Act of 1951 by Act 1 of 1989. 8A. Annual Report 2013-14, Ministry of Law and Justice, Government of India, p. 67. 9. Representation of the People, Amendment, Act, 1996, with effect from August 1, 1996. 10. As defined in Arms Act, 1959. 11. Presidential and Vice Presidential Elections, Amendment, Act, 1997. 12. Representation of the People, Amendment, Act, 1998. 13. Representation of the People, Amendment, Act, 1999. 14. Election Laws, Amendment, Act, 2003 and Conduct of Elections, Amendment, Rules, 2003. 15. Order dated March 27, 2003. 16. Representation of the People, Amendment, Act, 2003. 17. Election and Other Related Laws, Amendment, Act, 2000.